In relation to Section 48, we have now, I think, am I correct in saying we have agreed that subsections 2 and subsections 3 should be deleted from it. And we're in the position that Section 48 effectively replicates a provision of the 2002 legislation, simply saying that where a person has been appointed to judicial office, the notice shall, if it be the case, include a statement that the name of the person was recommended by the Commission to the Minister in accordance with the provisions of this Act, or be recommended to the Government under Section 44, as the case may be. Now, we are still stuck in the position, unfortunately, that Section 44 is wholly unacceptable, apparently, to the great majority of people in this House in its present form. And notwithstanding the attempts made by myself and other senators to amend the section, all of our proposed amendments have been rejected. And we're left in the situation that we're being asked to make provision for Section 44 of the bill, even though it appears that nobody in this House supports Section 44 as it stands.
We're on Section 48, as you know.
Yes, Senator. But I'm pointing out, I'm suggesting in subsection 1 of the section that we're now proposing to deal with, yes, we are making provision for Section 44 at Section 1, subparagraph B. We're making provision for a section to have effect, even though, as far as I know, nobody in this House, perhaps with the exception of the Sinn Féin party, supports that section in its present form. And that leaves us in a most...
no Sinn Féin to explain the position.
But it leaves us in a very strange position, is all I'm saying, Alaska here, that we are being asked to make provision for a section that none of us agree with, or that the great majority of us disagree with in its present form. And repeatedly I've asked that the Government publish the text of its proposed amendments to Section 44, so that we can, at this stage, consider whether we're content to allow paragraph B of subsection 1 remain as it is in the bill. I mean, if we're making provision for it, we should know what is intended to be done with it. But as things stand at the moment, as I say, most people in this House are opposed to the present Section 44, and we're left in the position that we're being asked to play blind man's buff as regards what the Section 44 will end up being. Now, the Minister knows well that this legislation has now, it's been debated at length in this House. There are a few things that should be put on the record of this House in that context. Number one, because it came to this House in what the Attorney General described as a dog's dinner condition, the Government couldn't override this House and simply deem it to be law, because it was a nonsense. So the Government has been effectively afflicted with the fact that it has to get the agreement of this House to its passage. The Commission of the European Union and the Greco Committee of the Council of Europe have condemned the scheme of this bill, and not merely have they done that, but it emerged from an FOI request recently that officials...
Senator, but I have to say here, look, we're now into the realm, once again, of second stage type speeches.
The Cahill of Seanad Éireann.
Please continue, Senator.
What I'm saying is this, that it is not acceptable that at a committee stage in this House we are being asked to consider a section which makes provision for another section which none of us agree with, and we aren't being told what its ultimate content will be. The Government has had plenty of time to make its wishes very clear in this regard. All it has to do is have the Minister state what he will be proposing for Section 44, and then this section we can consider what it actually means in that context. But he is constantly going back to the proposition that, the government will consider amendments to this bill when it has finished its committee stage. It will consider amendments to the bill and then publish them. And I don't think that's acceptable, and I don't think it's reasonable. I think that the Minister should specifically state how he sees Section 44 operating before we are asked to approve Section 48, which makes provision for Section 44.